Morning, everyone. I'm Cheryl Birch. I'm from.
Ms. Birch, can you just pull it a little bit closer towards you?
Good morning, everyone. I'm Cheryl Birch. I'm from Mataranka. I've lived in Mataranka for 50 years. I've been with the Mangawhai Youngman people for most of my time in Mataranka. I have an Indigenous name given to me by the Mangawhai people, Asanola. I'm here today to represent the Mangawhai, Alwa and Kui people. I'd like to introduce some of the people we got here today. Unfortunately, there's few apologies due to the fact that some of the elders could not attend today due to their frailness, health issues, of course no cars, and they would love to be here today to be able to represent and give evidence in support of no fracking for their country. They have asked me to bring it to the attention of you guys that is it possible that we could somehow have another hearing in Mataranka so that they could attend?
We will be going to Mataranka again, yes. I think I don't have the exact dates, but we in the latter half of August we will be going to Mataranka, yes.
And it would be the same sort of thing as today?
It'll be more of a community forum.
Yep.
But let me emphasise now that anybody can put in a submission at any time to the inquiry, either written, oral, video. We'll accept all that.
Okay, thank you. I'd like to introduce Velma Roberts. Paula. Paula Roberts, Mangawhai.
Welcome.
Philip Watson.
Welcome.
Stephen Sandy.
Welcome.
Johnny Billy.
Welcome.
Moses Silver.
Welcome.
Sadie Gibbs.
Welcome.
What's the old man's name now? Jimmy Thompson.
Welcome. Thank you very much for attending.
They're the only people that could attend today.
Thank you.
I'm Daniel Tapp, pastoralist on the Roper River. Not recently, at the first round of inquiries, I done a submission. That's basically my sort of main standing submission, and I'm here being asked by traditional owners. I've been involved with quite a few meetings with them, between them and the NLC, and just in support and to talk on behalf of these people.
Thank you very much. Whenever you're ready, thank you.
2015, March 21st, NT government announced in media it had secured a historic agreement, the first of shale gas exploration involving fracking on Aboriginal land trust in the Northern Territory. On the 25th of March 2015, a community meeting was held at Jugmingan. Residents found out about permits being issued. We do have a slideshow, I do believe. Who's doing the slideshow? Monica will be doing a slideshow. April 1st, residents wrote to the NT Government and Land Council asking for evidence of consolidation to support the granting of the EP 154. On the 3rd of April 2015, the April 2015 edition of the Land Rights News, a paper distributed by the Northern Land Council, claimed the fracking consents was qualified and the consolidations about the EP 154 had been held with appropriate traditional owners since 2010. 15th of April 2015, traditional owners attended a meeting at Mataranka Homestead, asked about the statement where over 140 people had written to the Chief Minister, Mr Giles, and NLC CEO, John Morrison, asking the licence be revoked due to inadequate consultation. NLC lawyers responded that they were and said they received letters but an agreement had already been made and there was nothing they could do about it. 17th of April 2015, a meeting between traditional owners and NLC lawyers, TOs, told they could go to jail if they obtained or showed anyone a copy of the gas agreement. 27th of April, senior TIOs wrote to NLC again outlining their concerns with the consultation process and calling for a review of the agreement. I have those letters here for you to look at.
Thank you.
The 11th of May, representatives with the community met with Northern Land Council, in which interval reviews is promised. To our knowledge, this has never occurred. No signatory to either letter was invited to give their point of view in any process. 20th of November 2015, senior Allawa and Mangara TOs met in Mataranka to discuss options for challenging the permit and seek legal support to process this. June 2016, Freedom of Information documents applied to get copies of the agreement. August 2016, over 350 Mangara Allawa people became applicants to potential court challenge over issuing the permit. This process took a few months and imposed on the way the Land Council runs consolidations where signatures are sought immediately or within a day or two. September 2017, Mataranka community rallied against fracking proposal in the region. Over 400 people attended from communities, tourism, businesses and nearby cattle station. 23rd January 2017, former Chief Minister Adam Giles, employed by Ms. Jean Reinhardt, owner of Jacaranda Minerals. This brought concern to community and a big conflict of interest. June 2017, Freedom of Information requested to the Department of Mines and Energy approved, but all information relevant to the consultation and agreement is denied by Northern Land Council under Freedom of Information exemption. In response to questioning the consolidation process of the EP 154, the Northern Land Council has only provided the claim that a 2-kilometre restriction on all surface water is evidence of consultation and is based on strict environmental conditions. But all our surface water is fed by underwater springs, and the country and the river systems are very sensitive. We are worried about any drilling or fracking in the area. Also, I might add that in the wet season, our Roper River can flood more than the extent of 2 kilometres. These conditions appear to have been made without regards to relevant underground or surface water studies for the affected regions and would do little to protect the underground surface water from drilling within the proximity of the catchment areas of the Roper River or Mataranka thermal springs. How are we supposed to negotiate agreement that protects our land, water and people when this is the best advice we have been giving? Fracking permits on Aboriginal land, paperwork from consultation meetings to discuss fracking proposals could only be provided by one traditional owner. These show a single gas well, a piece of pipeline and a bulldozer. The Northern Land Council have never used an interpreter during consultation to help explain the process of fracking or gas field developments. Often old people are forced to meet with land councils to discuss proposals without family present, especially younger people who can help them understand. Also, most of these people cannot read or write or sign their name.
At a couple of meetings that I've actually been to, requested by the TOs, I've actually been escorted from at least one of those meetings for not saying a single thing, and I was asked to go there to help the traditional owners, understand and digest exactly what was going on. So that consultation process seems to me to be, very one-sided.
The visual aids and description of the proposed work gives no indication of what scale and risk of the proposal may once the project moves onto production stage. These people do not understand that they thought it was going to be one well, which we all know that is not right. While no project is guaranteed to move to a production phase unless sufficient quantities of gas are found, it should be a requirement that the companies and land councils provide detailed information about what impact this may have in order for landholders to provide or withhold consent in an informal manner. Providing this information to landholders is critical to a genuine consultation process, as landholders on Aboriginal land trusts such as Manggarai Alawa Trust lose their rights to object to veto a proposal once it has been agreed to an exploration stage. Senior members of the Manggarai Alawa Land Trust have repeatedly requested information to help them understand the process leading to the granting of exploration permits EP 154. A record of consultation meetings held, including dates and locations of meetings. A record of what information was presented to landholders for these meetings to explain the natures and the risk of this project. A copy of the agreement with companies or even the names of landholders whose signature is on the agreement to determine whether consent was properly granted. To respect a legal injunction on behalf of the senior Manggarai elder Sheila Conway noted not to proceed with, she did not want the work to proceed with the EP 154 until documents had been provided. None of these documents have been provided by either the Northern Land Council and the Northern Territory Government. The following an expensive what is that word again?
Sorry, I'm just going to stop you there and just ask the noise to my left stop, please.
Sorry?
I'm just going to stop you while the noise is happening here and ask that stops, please. I want to concentrate on what you're saying. Thank you.
Yeah. The year-long application to obtain copies of evidence of consultation provided by the NT Government by the NLC Council before issuing the EP 154. All the relevant information pertaining to the consultation process and agreement making were denied by the Land Council. The lack of transparency and deliberate blocking of critical information for landholders mean only an expensive and difficult court remedy remains an option to challenge the issuing of the permit. We want to know why none of these agencies that hold this information are coming before this inquiry to answer the questions. NT Government, Department of Mines and Energy, the Northern Land Council, Hancock Prospecting, Jacaranda Minerals Joint Partner, Minerals Australia. The Government and Fracking Industry say we do not know enough about fracking, but we know about looking after the land and our communities, our culture, and we don't want this fracking to come in. If approval for fracking permits are being issued on our land, where is the responsibility of these agencies to make sure our people are informed before legal contracts are signed and for them to be able to understand what that legal contract is? Senior Manggarai elder Sheila Conway believes her name may be on the gas agreement, but she continues to deny the copy of the agreement or any confirmation as to whether her name is or isn't on the agreement or was required for consent of the EP 154. Most of our elders have moved on, God bless them, and they had spoken of being asked to sign without fully understanding what they were signing. I think that the copies of the agreement should be made available for the affected families and relevant TIOs. We believe the permit should be revoked under the provision of the Land Right Act and Petroleum Act NT because inadequate consultation with all relevant traditional owners for the area impacted by EP 154. The correct NT Petroleum Act exploration application processes have not been followed. The Department did not inadequately explain the exploration work provided to the traditional owners. The Aboriginal Land Rights Act would allow the NLC to call on the Mines Minister to revoke an EL if A and can be shown Proteiment did not fully explain its program and work, and it is believed the program of work will cause harm. We have the slideshows to show you. We're going to show that now.
Thank you.
We've got a slideshow to show you from an interim report, quotes from gas companies making agreement with people. Who's doing that? Okay, all right. Gas companies say Aboriginal people are informed about gas agreements and negotiations, but fracking is a new type of mining, and we haven't had our land before. On our land before. And information about the risks is coming to light every day. How we can make an informed decision as to why we don't know enough about the process or risk and don't have the resources for an independent legal or don't have technical advice given to us. We agree with the panel in an interim report that reviews appeal processes may apply to existing and future petroleum agreements. Without it, there is no justice for Indigenous communities and landholders. At present, our only remedy for assessing documents relating to the consultation process and granting of agreements is through a lengthy and costly court process, and once again I must add there, some of our elders may not be here to fight this, and this is why we need it sooner than later. An option would be denied most aggressive grievous Aboriginal landholders due to the lack of resources and difficulty negotiating the government and legal framework. Land councils exempt from freedom of information law means they do not have to provide anthropological information or information regarding financial assets that they may hold on behalf of an Aboriginal landholder group or individual. It is our strong view that the exemption from the Freedom of Information Act allows Aboriginal land councils to operate with a very low degree of transparency and accountability that is exacerbating conflicts in our community and denying us enjoyment of our full rights as landholders under the Aboriginal Land Act. We ask the panel to consider our case and study and make a recommendation that appeals and review rights are afforded all landholders impacted by shale gas and petroleum permits. And that the exemption from freedom of information, or freedom of information law be removed from all territory land councils to improve access to the natural justice for the Aboriginal landholders. The fracking permit over our land be scrapped. The inquiry investigate why critical information about gas agreement is being denied to Aboriginal landholders. That the conduct of the former Chief Minister Adam Giles, Mines and Energy Minister, to be referred to the Independent Commission against corruption investigation given the perceived conflict of interest with his new role as an employee of the Hancock Prospecting. We do not believe that natural gas is afforded to... Oh, sorry, I'm getting carried away here. Natural justice is afforded to the Aboriginal landholders under the current regime of consultation and issuing of permits for shale gas exploration on Aboriginal land. All agreements on Aboriginal land trusts and native land titles should be made available to relevant landholders. The exemption from freedom of information law for Aboriginal land councils should be revoked to avoid lengthy and expensive court processes and conflict in communities. We have shown we are determined to fight to protect our land. We don't want the risks of fracking in our community. We have held big protests. We have told the Land Council we're not going to any more meetings to talk about gas plans until they show us the record of meetings and agreements. We have written to the governments and gas companies. This inquiry is only looking into detail at fracking in the Beetaloo Basin. But what about all the other communities now locked into agreement? We are fighting, and what will you be recommending for us as landholders? Our community has shown time and time again we don't support fracking in the region. We do not know any Aboriginal communities where there is strong support for this type of mining. We would like to see the inquiry recommend a vote to be held on whether we have a fracking ban across the territory. I have the letters here that were written and signed by the Mangarai traditional owners for you to look at.
Thank you very much. You also were reading a notice from a document in giving your presentation. Are you prepared to make a copy of that document available?
Sorry. There behind you on the screen is also that's our fracking rally that we had in Matarenka, where I think there was about 150 people, 200 people in that one. It was well represented. as I said, I apologise for people that could not attend. Well, I've just been read all through that there. Anything you want to add? That's the piece out of the Land Council newsletter. And you can see in there where they've given you a kilometre each side of the river exempt from fracking, which is, like I said, the Roper River is known to flood more than 2 kilometres wide. A decent flood could be more than 4.
With horizontal drilling, obviously you can go under the river from a kilometre away.
And in that same area there is limestone, which has lots and lots of springs, none of them known to public, but they are there. Like some of them could be that round, some of them are as big as bathtubs, where they're natural springs underneath the rocks and do feed the river system.
All that stuff's on the paperwork that you'll put forward. Just sorry for my little bit of disorganisation, but I've been out bush for the last 6 weeks with no phone or internet, and I've actually drove back about 500 k's requested by the TOs just to express some of their concerns, and I'm just wondering if I could just rattle off those quickly and so we don't run out of time.
Go for it.
Some of their concerns is a lot of this fracking is supposedly, or it's being talked about as being out in remote areas, and they'd just like to say that these remote areas are their homes, and it's my home, in fact, as well, living on a pastoral station, and just recently I've been contract mustering. I had 12 or 13 people in the camp. We live out in the bush, and that's where we work, out in these remote areas, 500 kilometres from here. So this remote issue should be just canned. I mean, and the same thing on these remote areas. The water comes from these same remote areas, like the Beetaloo Basin there now. I mean, that's right on top of the Tyndall Aquifer, which basically waters from Katherine to Tennant Creek, the central half of the territory, all the Manggarai and Land Trust area, Roper River, So basically anywhere that's, it's endangering the water should be excluded. The well integrity issue is still never been, completed there. When I say completed, never been, it's always going to be an issue. And in time, all wells will fail, no matter what they say, and how strong the robust regulations are, or strength of steel and cement. It just hasn't got the capacity to withstand, the trillions and trillions of tonnes of pressure in natural earth movement. The industrialisation of the landscape, it's never going to be back again. And, say in the Umungi area there, for instance, on Beetaloo Station, the landowners there are talking about cranking up their cattle herds to 80 to 100,000 head. That's just on one property, with this new watering system where they water cattle, every 5 kilometres with pipelines, roads, tanks and everything. And then you've got a frack field on top of that. It's just like an overworn spider web to me. And also the traditional owners have got those concerns. And on the insurance and guarantee side of things, there's no, the gas companies or government, if the government makes it mandatory for us to let the gas companies onto our land and then basically wipe their hands of any insurance or guarantees, it's just up to us and, drill and hope, and that's sort of not good enough, particularly with our water, and as far as the financial economics of it goes, I mean, I just find it absurd that someone can be talking about money over water. It just doesn't comprehend in my or their sort of beliefs. And as an example there, on the insurance and guarantees side of things, in Halliburton's submission earlier on in Darwin, when asked by the panel about who's responsible for drilling and fracturing a well, basically they said to the panel that they would come back to the panel. I would have thought they would have had an answer on the table to say who's responsible. To me and a lot of people, that sort of says basically they're passing on the buck and having no responsibilities for their own actions. And as far as gas well integrity goes, if a well does fail, how do they fix a contaminated aquifer or a depleted aquifer? As far as bond money goes, there's no amount of money that's going to replace, an aquifer that's contaminated or depleted. And on top of that, on the water usage alone, without the contamination issues, it's massive amounts of water. I think I've put those figures in my last submission. And, going on top of that with, a big Thirsty Develop the North program happening, plus the sustainable industries around that all rely on water from every industry that you can possibly think of relies on water. And the baseline testing in here, there's no sort of strong baseline testing, and one would think that to get half an idea on some sort of average, you would need at least 10 years of strong, robust testing, not just in one area, obviously all these areas that are under threat. And then on the grounds of the uncertainty and the high risk, on the grounds of the uncertainties and the high risks that are involved in fracking, we're calling for a total ban, and the traditional owners want a fracking banned on their land, on traditional owned land, which some coincide on pastoral leases, such as mine.
Thank you.
I do have, like I said, a few traditional owners here that would like to get up and speak on behalf of this inquiry today.
All right, yes.
I'd like to call Paula Roberts.
I'll just give her the seat here.
Sorry, Daniel?
I'll just give them the seats here.
Yes, please, thank you. Yes, thank you, Ms. Roberts.
My name is Paula Roberts. I represent the Mangere people. I belong to a place called Jitmingan. I'm speaking on behalf of my people, and I'm saying no to fracking, because, like she said, the waterway in the country is too beautiful to destroy. That land is our life. That water in the source of our life. So what I'm saying now, I'm saying no. Fracking.
Thank you very much. Yes.
Thank you.
I'd like to read out these letters that were sent to the Northern Land Council and Mr. Giles. Is that okay? Or would you
yes,
rather...
we are running out of time, but
okay.
Yes, absolutely.
This one is 23rd of March 2016. Call to review process of granting petroleum licence EP 154 and EP 153. On behalf of traditional owners of the Alawakuri and Mangere Land Trust, we have major concerns with the granting of petroleum licence EP 154 and EP 153. We maintain that we are not properly consulted before the agreement was signed and licence were given approval by the Northern Land Council. We are in agreement that the process and risks of onshore shale gas fracking and scope of the work plan was not explained to us. We believe there has been failure to undertake proper consultation. We are calling for a review for the consultation process for those 2 exploration licences to be revoked to allow proper process. This issue has been previously raised in a letter to the Northern Land Council on the 27th of April 2015, where many residents of traditional owners signed on the below letter. In March, the NT government announced approval of the petroleum licence 1454 over the Manggarai Land Trust. Representatives of your organisation have claimed that consultation was with traditional owners and adequate to reach an agreement for exploration and potentially gas mining with Jacaranda Minerals and Minerals Australia. We have previously written to you on behalf of 140 residents of Jugmingan who reject this claim and have called for the licence to be revoked. Northern Land Council lawyer Charlotte Dean and 2 mining officers visited Jugmingan on Friday the 17th of April for an unadvertised meeting in response to receiving our letters. Traditional owners raised concern with the lack of transparency involved in the consultation process and were told that they had no option to withdraw from any agreement. We request to cite a copy of the agreement, and those present were told it was confidential. We were also denied the names of the signatories of the agreement. The NLC cannot claim that this process constitutes informed consent, that we are actively being denied information and documents about the agreement, which opens up our lands to the risk of damaging gas mining. We now write on behalf of the Manggarai traditional owners to request that the Northern Land Council immediately provide us with the copies of the following documents: the agreement between Manggarai traditional owners and Jacaranda Minerals Australia for petroleum licence 154, copies of any maps relating to the agreement and exploration boundaries, exclude zones, sacred sites, community living areas and water sources, the name of signatories to the agreement and minutes from any meetings held and discussed with that agreement. We are asking that the Northern Land Council immediately review its conduct in relation to the information of this agreement and seek to have this matter discussed as an agenda item at the upcoming Manggarai Land Trust meeting on May 7th. Concerns were raised in a letter to the Chief Minister Adam Giles on April 1st, 2015. We, as the Manggarai traditional owners and residents of Jugmingan and Elsie Station, are writing to the NT Government because the petroleum exploration licence EL154 was recently approved over our land and surrounding pastoral stations. We were not told about the risks to our health, water and environment from fracking and shale gas drilling. We do not want any fracking for gas to go ahead on our land. We want to protect the country for future generations. We are now calling for a full review to the process of granting petroleum licence EP154 and EP153 for those 2 petroleum exploration licences to be revoked to allow the proper process. And I have all the signatures here.
Thank you.
I also have the letter that they wrote to Mr. Giles on the 1st of April 2015.
Is that a letter that can be given to the inquiry to be posted on the inquiry website? I am conscious of time.
All right, no worries.
I've got a number of other presenters here and we've got a full day. So was there anything else you wanted to say to the panel that wasn't contained in a document that we will gratefully receive and absolutely put up on our website?
Yes, well, I think Johnny Billy would like to say something, if it's possible.
Yes, absolutely. Thank you.
Hi, my name is Johnny Billy, and on behalf of the frackings of the territory.
If you can speak closer to the microphone, sir. Thank you.
Yeah, you can hear me now. So we don't want this fracking in our community, so we'd like to stop it, and we want to get everything organized as we in our panels of my rentals. We all had this fracking with the frackings in Croatia, and so we had that 1 week meeting with them, and so we told them that we didn't stop it. So as far as they're concerned, like on behalf of Malarai and Manuary and all about part of our community, we said no, we won't stop it.
Thank you. Thank you very much.
Just couldn't understand, in case you couldn't understand there, he was basically saying that...
I could understand.
About the consultation again in Mataranka. He was wanting to submit to that as well.
That we will be in Mataranka very shortly.
Yep,
thank you. Does that conclude your presentation?
Do any of you other mob want to say anything? Philip? Philip Watson.
Thank you.
Hello, I'm Philip Watson. I'm just talking on behalf of our Alamo tribe. That we had all this meeting all about this fracking before. And bush is our land. We don't live in upstairs house. We live in the bush. We don't want that fracking to go ahead. No. We want our land to be our land, like our grandfather and grandmother had it before us. And, you know, as our children growing up, we want to see it that way. My kid will want to see the land as I see it, you know, when I grow up. And bush really our land. We live out there. We don't want to fracking.
Thank you. Thank you very much, Mr. Watson.
Yeah, I think that's the end of...
Thank you.
Thank
you. Thank you very much. And we'll be open up the for questions from the panel. But before I do so, I do want to thank the people who came here from, in some cases, great distances. Everybody who came here and to speak with the panel today and to make time for the inquiry. We're very appreciative that you've come here and told us all your views and opinions. Thank you. Yes. Any questions? Dr. Ritchie.
I'd just like to get it clear in my mind that as far as what you're saying is that an agreement with Jacaranda Minerals was concluded to give them allow them to proceed with an exploration license over the land trust. The land trust from Elsie, the Elsie Land Trust, or the Chilkamingan Land Trust. So it's Aboriginal land under the Land Rights Act, and that agreement is still a current agreement. That deal still exists, and that all the issues that you've talked about now are still live issues. There is, in your view, as the view of a group of traditional owners, that agreement is an invalid agreement, and that is a matter of ongoing litigation with the Lands Council. Is that correct?
Yes, and the agreement actually has been finally handed over, but several pages of the devil in the details, so-called, have been blacked out in those sort of explaining those consultation processes. So.
And just to follow up, is there any legal action pending at the moment? Is this before the courts at the moment?
No, it's not before the courts. Okay. As mentioned there, it's obviously wanting to avoid lengthy and costly cases.
Thank you.
All right, I might leave it there. But you made a couple of comments were made by both the presenters. One was in relation to the departments not appearing before the inquiry. That was something that was noted by the panel yesterday and is noted again. They haven't appeared to date before the inquiry. That's not to say that they haven't provided assistance. Certainly they have provided us with information and answered our correspondence, but you're quite right. No government department has appeared before this inquiry in person. In relation to Hancock, though, as a matter of fairness, I should say that we've recently received a request for Hancock to appear in front of the inquiry. They're a little out of time for this round of consultations, but we're considering their application or request. So, but thank you again for making the time to come and meet with the panel today. We're very grateful, and certainly I think you've given a good example with EP 154153 about where the process and how the process can go very wrong if adequate information is not given, if adequate consultation does not take place. Thank you. I think we have... Sorry, yes.
Just one other thing there with the consultation process. I mean, I'm not sure whether I'm supposed to be different or anything, but from a personal experience with the application or the granted application that was handed on my property in, I think it was 2012, I just got a letter in the mail saying that exploration licence 163, I think it is, has been granted over your land, and that's the only bit of correspondence I've ever had of anything of any sort, and that was by granted to Santos.
Thank you. So no one ever telephoned you or came knocking or anything like that to explain the process? Or thank you very much. All right. I think we have our next presenters here. Thank you.